Good evening to you all, and welcome to our session number 2 in our revision towards the 2025 Ghana School of Law Entrance Examination. So this is essentially a tutorial session, not so much of a formal lecture. So before we start, we will seek divine assistance briefly, and then we will continue. Heavenly Father, we thank you for the gift of knowledge and opportunity to prepare for this important journey. Grant us clarity of mind, diligence in study, and humility to learn. Bless our discussions today, that they may sharpen our understanding and guide us towards wisdom and also to success in our exams. We entrust our efforts into your hands, knowing that success comes from you. Amen. Okay, so we are going to do actually three, let me realistically, because of time, 2 sessions. We quickly get session 2 through, and then we have some 2-3 minutes pause, and then we start with session 3. So session 2, according to the schedule we set up yesterday, is to look at how to structure your answers and how to use authorities. So we hope that at the end of this, we should be able to cite cases appropriately as part of writing answers that will attract the attention of your examiners to give you a good scores, and to structure your answers logically using IRAC, or what I call the facts methods. We come and talk about each of them. So the IRAC applies mainly to problem-based questions, and then the facts, to help you to use case law properly when you're writing essays. Yeah, so we also look at some examples of how you should address, or you should present or compose your answers. So first of all, we cannot overemphasize the role of case law in writing your exams. The reason being that we're a common law jurisdiction, meaning that our law is developed and conceptualized through case law, through decided cases. And if that is so, what it means is that even where the particular area of the law has been significantly codified in the form of you having legislation, it is the decisions of the court which actually give life to provisions of the legislation in real life situations. So you have to make effort to cite cases. So examiners, but of course, would like to see you bringing out clearly the principle of law which the case stands for. So the principle of law the case stands for is what we call the ratio decidendi, as it were. And then the name or the case represent from which propounded that particular principle. This is very elementary, or you need to remind ourselves. And thirdly, it's not enough to mention the case. You must apply it to the facts of the exam question. So what it means is that you have to avoid dumping cases, right? So you read some scripts, and examiners will tell you that some students have virtually dumped cases by simply listing cases. They list the cases just like that. Now, if you do that, you will not have connected the case to the legal principle and facts and make it relevant to the question so you not get the good marks. So keep that in mind. Of course, this is a examination, so we don't expect you to provide, as I said, the the law report, right? If you're able to provide the law report for cases that you cite, that will even raise the suspicion as whether you've had the benefit of the questions uh, or the marking scheme as it were before coming, because it's not possible for you to be able to cite the case with the citation. So we are not talking about that. So we are just talking about the name of the case. And now, when you forget, let's say, the name of the case, we've talked about yesterday, question came up, and that is why I'm going back to this. When you forget the name of the case, that is not the end of the road for you. Okay? So if you cannot remember, describe the case briefly. So let's suppose that you know the case, let's say NPP versus the Attorney General, right? NPP versus Attorney General, let's say the 31st December case. Unless, of course, we know just like plethora of authorities, the Supreme Court has held that the Constitution is the supreme law of Ghana. And of course, the Constitution itself says that. So let's suppose that you don't remember the name of the case, but you remember what happened in the case. You can describe the case briefly uh, to provide evidence that yes, you know that there's a decided case on the particular point. Just that because of observation pressure, you've forgotten the name. That can be understood. Now, again, where you have a number of cases, okay, where you have a number of cases, don't forget the hierarchy of courts. If the High Court has a decision on a principle, and the Supreme Court has a decision, you must certainly go to the Supreme Court because the Supreme Court is the apex court, and the decision of the Supreme Court binds all the court. It is only where the Supreme Court does not have a decision, and then you go to the Court of Appeal. If the Court of Appeal does not have any decision, then if a High Court has a decision, then you can use that as well. Because yeah, and that is important. So don't be going for lower level decision when there are higher level decisions, okay, within the superior course of judicature. So we will not belabor that point. Just a reminder. You know this already. Now, when you are structuring your answers, there are two, if you like, ways. The IRAC method, we knew it already. And yesterday I indicated that I have one particular recording, if you go to the Ghana Law TV previously, where I actually spent time to walk through how the IRAC or the IPAC is actually used in answering problem-based question. So you identify the legal question or the issue, state the principle of law, and then the application, you apply the law to the facts, and then conclusion, that you state a reasoned answer. Typically, I mean, this works well for uh, what do you call the problem-based question. So let's suppose that you are dealing with maybe uh, an essay. An essay, you may not, you don't have any particular questions to actually raise, as it were, but you need to use the case to support aspects of your answer. You just summarize the material facts of the case, and then you uh, cite the relevant aspects. Then you use it to buttress whatever point that you are making. But of course, whether facts or IRAC, if you look at the mechanics, just like having like the IPAC, they are essentially the same. Now you've done this, so we're not going to waste time on this. We move on to some substantive area quickly. And then There's a this let me make the point. There's this confusion which is going on in our country. There's two schools of thought depending upon which university you studied, right? In some universities, the IPAC or the IRAC, students will actually have to write, they are taught to write area of law, then you put it there, issues, principles or rules, then they state it. And then they come and write application and analysis. Then they do conclusion. Well, some universities will also say it's not necessary to be writing no principles of law and then before you write the actual principles and so on. My advice is that there are no hard and fast rules regarding that. The most important thing is the substance, okay? So, have you identified the relevant issues, the legal questions? Have you been able to state the relevant principles? Have you been able to apply them to the facts and then draw the necessary conclusion, of course, buttressing your analysis with any particular case law whose facts may be on all fours with what you have before you and so on. I mean, once you're able to do that, whether you wrote issues, you actually wrote the word issues, then you wrote no analysis and application, principle analysis application, conclusion, it's not fatal. It's a substance which matters because there's no, if you like, a national blueprint provided by the IEC or those who manage the examination. So I think the marking scheme should not, in my view, be so hard on that by the substance, as whether be able to identify the issues or the particular relevant area of law, if you're able to state the principles and the cases from which they emanate or the relevant legislation, and then you're able to do the application and the analysis and draw the conclusion. I think that is what is important. But the form, there can be some slight variations, and I think that shouldn't worry you. That shouldn't waste your time. Yeah, so we've said that avoid listing cases without principles, and then defining concept vaguely without authority. That is also not good. You are not authority, so whatever you state as a concept or as a principle, you must situate it within an authority, either provision of the constitution, provision of a legislation, or decided case, as it were. And I've also told you yesterday that you avoid writing long introductions, right, without answering the question. Long introductions are not the answers to the question. If you write a beautiful, lengthy introduction and you don't answer the question, you will not pass. And no one also fail to conclude. So, the bottom line is that each argument you make, try and have it anchored in authority. Keep introduction short. And yesterday I said that the most lengthy introduction should not be more than half page. So I will even suggest 3 to 4 lines maximum. And then you move on to the heart of the question. If it is an essay question, you can use headings or subheadings like to let the point stand out. Even if it's a problem-based question, when you have actually done the various issues, we take the issues one after the other as a topic, if you like, you underline it or whatever. And under it, you state the relevant principles and then the case law. And then you do the application, the analysis, you draw the conclusion so that your answer will actually stand out well. So let's assume you have maybe something like explain the supremacy of the 1992 Constitution. We don't expect you to write fast, applicable, or reason. No, this is just just for purposes of, if you like, education. So this is an essay question. For that matter, you have an introduction, and then introduction, as we said, should not be that lengthy. The question is about supremacy of the Constitution, isn't it? So we will expect you to explain briefly when we say supremacy of the Constitution, what does it mean? Okay. If you want to open it up, don't let it be too wide. So you may want to tell us what the Constitution is briefly, but don't go and tell us everything. How do you call it? Casey Ware and Benoit and other scholars have written, let's say, extensively about uh, what the uh, the Constitution is, the types of Constitution, and so on. That is not what the question is about. The question is quite straightforward. That explain supremacy of the Constitution, the 1922 Constitution, supremacy of the 1922 Constitution with the reference to decided cases. So go straight. The introduction, yes, you are telling us the question about supremacy of the Constitution. You explain to us briefly what the Constitution is. When we say supremacy, what does it mean? In what way is the Constitution supreme? The relevant authorities or the applicable law. But as I said, you are not going to write applicable law. That is why I have crossed it out. I'm just using that just for purpose to let you know that you must anchor your argument in authority. So we have the Constitution, Article 1, Clause 2, the supremacy of the Constitution, that the Constitution is the highest law or the paramount law, the basic law. And for that matter, any law which is not in harmony or which is not consistent with this is to the extent of the inconsistency null and not void. This is something you know already. We have so many cases. To form as Attorney General, of course, an old authority, but it has been adopted and followed under the 1992 Constitution going back to 31st December case, MP versus Attorney General, Messima versus Attorney General, IGP, NPP against IGP, and so on. So many cases. So, in terms of supremacy of the Constitution, if you want authorities to substantiate that, apart from the constitutional provision itself, even if you want 100 cases, you can get, isn't it? Because essentially, almost all the cases about constitutional law are cases also about what we call supremacy of the Constitution in one way or the other. So let's keep that in mind. So I know where you, for example, attempted to solve a question like that and you didn't provide cases or you provided just one case, that will not suffice, okay? The examiner will not state, let's say, the number of cases, but make effort. If you are not giving cases at all, try and give about 4, especially if you have an open-ended question like this. So give about 4 cases. And this is an area, as I said, if you want even like the 100 cases, so to speak, you can get, isn't it? So you shouldn't struggle. Because if you understand constitutional law, you have to know that almost all the cases that go to Supreme Court for interpretation or enforcement, there are also cases which impinge on the supremacy of the Constitution clause. So that shouldn't be a problem at all. So let us keep that in mind. So as you know, the Constitution binds all authorities, entities, and for that matter, it is a duty of the Supreme Court and, of course, all other courts to uphold the Constitution and strike down any acts or laws which are inconsistent, which are not in harmony with it. This is just a representative, just trying to draw your attention to how you should try and think through your answers, avoid waffling, and stay within the remit of the question. And don't also forget to neglect all the essential aspects of the question. So, for example, if you know everything about supremacy of the Constitution and all that you know is just about one case, or don't even mention any case, then you should know that you are not, for example, going to pass that particular question, as it were. So let's take a question like uh, Constitution must be living uh, document, okay, capable of evolving with the society they govern. Analyze the amendment and review procedures under the 1992 Constitution of Ghana. We are just trying to, this session, we are just still trying to look at structuring of an answer. So we are not looking at any particular subject. So all these are just, if you like, illustrations. So what should be the objectives of your answer? The question is pretty straightforward. A statement has been given you that constitutions must be living documents capable of evolving with society they govern. Then the question, analyze amendment and review procedures under the 1992 Constitution of Ghana. So, if you have a question like this, you must always stay focused. Two things. Don't ignore the statement, right, which has been given as a context, because the statement or the quotation which has been provided by the examiner is a context, like the background within which the question is supposed to be tackled or responded to. So let us keep that in mind, okay? So the answer should seek to achieve the following objective. You must interpret the living document. If you look at the statement, it says Constitution must be living documents. So when we say living documents, what does it mean? Okay. Even if you want to be a little bit, you know, extra ambitious, I want to explain what the Constitution is, that is fine. But then don't let your attempt to define Constitution mislead you and then start telling us about all the classifications of constitution and so on and so on and so forth. That may be interesting, but there may not be enough credit for all those unsolicited elaboration uh, by the marking scheme. So you might have expended energy and space and time. But maybe the marking scheme may be giving no credit probably for all that. So you have to be careful. So your answer should seek to interpret the phrase living document in a constitutional document, in a constitutional context, then explain the amendment procedures under the 1992 Constitution, and attempt to draw a distinction between entrenched and non-entrenched provisions. Your answer must also describe the constitutional review mechanism, the review mechanism of our Constitution and its history, especially the 2010 Constitutional Review Commission. I am aware that as we speak, we have what we call the 2025 Constitutional Review Committee, as it were, or constitutional reform, however they call it. But their work is still ongoing. Their work has not concluded yet. And for that matter, unless you have been asked to send proposals, right? Proposals for reforms to the Constitutional Review Committee. Otherwise, in terms of evaluating their work vis-a-vis constitutional review and so on, that will be premature because their work is still work in process. The only thing which you could, for example, be invited in terms of examination question will probably be you, thinking along the sort of reforms which are being proposed or what you would like to propose for consideration of the committee and why. Those are the kind of things that you should be exercising your minds about as we learn. That assuming you've been asked to submit a memo or submit proposals, right? to the Constitutional Review Committee of Professor H. K. Prempe and his friends who are working on it. What are the areas of the Constitution that you would like to see amendment or reform? And in that regard, what problem have you identified? And what solution are you proposing that you are convinced would actually cure the problem that you have identified? So maybe you can be exercising your minds along that line. Okay, so coming back to our question that we are trying to address, your answer should also have the goal of evaluating how effectively the constitution review mechanisms have allowed the constitution to evolve in practice. So, in what ways will you say that the review mechanism of the constitution, how it is structured or designed, has actually given room for the constitution itself to evolve gradually according to happenings in society? In what ways? And then, of course, you must provide a conclusion. And then your conclusion must tie back to the idea of constitutional dynamism. Constitutional dynamism, the same as talking about the constitution as being a living document. So that was what the question was about. So when you have finished everything, you must actually tie the loose ends of your discussion by having like the conclusion. Good. So an ideal answer, right, for the question that we pose, that is, constitution must be a living document capable of evolving to society they govern, analyze the amendment and review procedures under the 1992 Constitution of Ghana. We have looked at, if you like, what the answer should seek to achieve. So an ideal answer would, in the introduction, define a living constitution as a legal framework adaptable to socio-political change. I mean, that is what it means to say that the constitution is like a living organism. And for us, this is not new. You remember the dictum of Justice Sowa in Tufo versus Attorney General, which has become like a cliche and has been carried on in so many line of cases. The constitution is a living organism capable of growth, mirroring the aspiration of the people, so on and so forth. So when we say that, all that we're saying is that the constitution is not static, okay? It's not static. The constitution evolves, it grows, it adapts to, or it's responsive. The constitution responds to changes which occur in the socio-political environment. So that is one of the things that we have to keep in mind. Then, as part of the introduction to, we must state the relevance. We need to contextualize it. And how do we do that? So Ghana's constitution include mechanism for change, amendments, and periodic review. So all this will form part of the introduction. And as I said earlier on, the introduction shouldn't be lengthy. You shouldn't write, 1 page, 2 page, or trying to do introduction. No, please. Even in real life, even when you are writing article for publication and other things, introduction are not that long. So if you have a winding introduction, it's create unnecessary suspense for your examiners. And when the suspense have been created and then you are not able to deliver, then they become very disappointed. And that will not augur well in terms of what will be awarded to you. So be careful about that. Then an ideal response will look at the amendment procedure under the 1992 Constitution. As you know, we have the entrenched provisions. If you look at the article, I think 290, if you look at Article 290 of the Constitution, yeah, so the procedure has been provided, and we have a list of provisions which are called entrenched. So the category has been provided. So which aspects of the Constitution are classified as entrenched provision, for which reason the procedure for amending entrenched provisions apply. So just look at the list and get yourself familiarized with at least, if you don't remember anything at all, you should remember at least six areas of the Constitution which are entrenched. There are a lot of them there. The Constitution is Articles 1, 2, and 3. The territories of Ghana, the laws of Ghana, Article 11, the whole of Chapter 5, fundamental human rights. And then when it comes to the arms of government, the whole of executive, the whole of Chapter 8 is an entrenched provision as it were. And so many other no so many other provisions. The list is provided over there. So what is the procedure? Bill must be gazetted for 6 months before it will even be introduced. Referendum will be held, and when the referendum is held, there should be a minimum turnout of 40% of those who have registered to vote. And out of the 40% of the registered voters actually taking part in the vote, 75% of those who actually took part, that is the 40%, must agree with the proposed amendment. So there should be a minimum of 75% yes votes. If that is attained, Parliament must approve it with two-thirds what? Majority. And of course, the basic purpose is to protect foundational values upon which our constitutional architecture is what erected from easy alteration. So if you take, let's say, the executive, for example, we don't want any confusion in our body politics, right? So if you look at it, interestingly, every aspect of the provisions on the executive, okay? If you look at the 290, clause 1, paragraph F, in lessening the entrenched provision, when you go to executive, say that the executive chapter 8. So the whole of chapter 8, everything relating to the executives, the president, the vice president, appointment of ministers, the powers of the president, and so on and so forth, the attorney general, these are entrenched provisions because we do not want changes to be made at at will or anyhow. For example, currently, there were some talks about whether the current president would go for another term, whether something should be done. assuming that provision was not entrenched, and we have, let's say, a situation of having a ruling government which has a comfortable, let's say, majority in parliament, they can easily do whatever amendment that they deem fit. And that is why the framers of the Constitution said that let us put some no breaks so that it will be a conversation of the entire society. If the entire society majority agree that this is the way it should go, well and good. Then we also have the non-entrenched. The non-entrenched, if you look at Article 291, the non-entrenched provisions are there, and the non-entrenched, as the name suggests, they don't require elaborate or laborious procedure for their amendment because they concern less critical provisions, maybe things relating to some administrative structures and so on. For that matter, the bill is gazetted for, let's say, 10 days. Parliament passes it, and it needs the two-thirds majority of um, all MPs. And the reason for relatively no easier no method of amending is to allow flexibility and also responsiveness to evolving governance needs. If you look at those provisions which are not entrenched, you notice that they don't really go to the very heart of what can create problems for us as a society. And for that matter, if there are no changes and such provisions also warrant change, it should be easier for our lawmakers to do that. But then where the change desired impinge on very foundational values, things which go to the very core or fabric of our society, then we need the entire country to come in. So, if you look at the fact that we have a tired approach, that is to say that we have bifurcated or we have divided the ways in which the Constitution can be amended, it is for good reason. It's not for nothing that some have been categorized as entrenched and others have been categorized as non-entrenched. So such bifurcation or such division or categorization in terms of the amendment approach allows for differential protection. Some, for example, let's say Chapter 5 of the Constitution, fundamental human rights, okay? They are something which affect everyone. Even if the rest of the Constitution, if they don't matter to you, okay? If you say that for me, I am really an ordinary person, I don't really care about big things. I don't care about who is the president, who is the MP, or who is the chief justice or the judges. I don't care really about all that. You care about human rights, fundamental, because they will affect you directly. Your freedom of expression, movement, no, your right to own a property, freedom of assembly, procession, right? The right not to be subjected to inhumane, degrading treatment, the right to fair trial, uh, then the right to personal liberty, the police and anybody not to harass you without due process. These are matters which will definitely affect him. And so, for good reason, it is also made entrenched. So the whole chapter 5 is part of what entrenched. So if you are going to amend it, then the entire society must be part of the conversation and not just the elected political class. So in that respect, it provides a deep stability for core provisions. And at the same time, there's an adaptability for others. As and when things change, it is possible, especially matters which do not strike at the very foundation of our society, to be adjusted to reflect changing needs and circumstances. So, if you remember your typology of constitution or classification of constitution, especially KC Ware, from Constitutional Law 101, KC Ware, when we're doing the classification of constitution, you talk about rigid constitution and then flexible constitution. So we may say that our constitution is neither rigid nor flexible. Our constitution reflects a hybrid constitutional model. It's flexible yet resilient. Then the good response to the question will also talk about um, constitutional review. Constitutional review as a concept, what is it? A constitutional review goes beyond individual amendments. It's a systematic examination of the entire constitutional framework. And if we look at the ongoing exercise, and then that is what we are witnessing, similar to what we had in 2010. 2010, we had a constitutional review, and as we said, it's not just about looking at a particular, just an individual amendment. You are looking at, going back to the drawing board, taking the constitution or the constitutional arrangements, and go back to the drawing board again to ask yourself, how can we re-engineer? How can we re-tweak, the constitutional arrangements as originally designed, so as to accommodate what current society wants and what it would like to have in the foreseeable future. So that is the constitutional review. And so what that, and of course, after a significant period of operationalizing a particular constitution, that may be necessary. And if you look at ours, our constitution came into force, 7 January 1993, and we are in 2025. So we've done a lot, more than 30 years of practicing it. So it's not out of place. Even 2010, when we had done just about, I think, less than even 20 years, we I think yeah, so so 2010, because the constitution in 1993, so yeah, so when we had done less than 20 years, we even had a constitutional review commission, as we recall, our late president Mills. So public views were collected, as we know, from Ghana and diaspora. And if we look at the report of the Constitutional Review Commission, there were over 900 recommendations which were made from the various submissions. And they related to the following thematic areas: presidential powers, decentralization, Council of State reform, human rights and governance reform. Then the government later initiated a white paper, accepting some and rejecting others. But there was a problem. The problem was that we did not have a comprehensive implementation, and the reform process largely came to a halt, or it was stalled. But of course, we've gone back to the that exercise again. As you notice, the current government has initiated another constitutional review exercise. So it is too early in the day to talk about its effectiveness because they've not even submitted their report yet. So usually, constitutional review is not smooth as is expected because of political inertia. Uh, when proposals, even recommendations have been made, you need the government of the day to actually be interested in it because, mind you, it also have to involve parliament, okay? And if we look at the constitution, yes, we have a private members bill, but then where a bill is going to have financial implications on the national coffers or the budget, the constitution says clearly that it is the government which must introduce such bill. So that is quite clear. I think if you look at the Article 108 of the Constitution, Settlement of all financial matters, that Parliament shall not, unless the bill is introduced or the motion introduced by on behalf of the President, proceed to do any bill which has financial implication, either imposing tax or spending from the public revenue, contingency fund, consolidated fund, and so on. So if the government of the day is not keen about actually implementing the reforms, it will not go very far. That is how political inertia is one of the challenges. So there's a lack of legislative follow-through, so the same point. And there's a risk that constitutional review may become symbolic, not substantive. Like go through the motions and let it become part of the political rhetoric. Yes, we are currently seeking to reform the constitution. So let's say that when there's a problem, you quickly have a defense. There's an ongoing constitutional review reform. So let us wait for that to be concluded. Yeah, so those are some of the things. In that case, become symbolic rather than just substantive. So as I said, in terms of evaluation of effectiveness, here we are talking about the arrangement in the Constitution for its amendments. How effective are they in view of what we have discussed? If you look at the provision, for example, relating to entrenched provisions and non-entrenched, what are the strengths? So a good answer will make the point that the tied system, when we say like the tied system, that is having the bifurcated or the separated system for the different types of provisions, amendment, as we have seen, entrenched and non-entrenched. It promotes democratic legitimacy, as we have explained, matters relating to very sensitive or the very foundational values will have to involve the entire citizenry and not just the elected political class. Again, uh, there's also high public participation for entrenched amendments. And that is why we have like the threshold that even for entrenched amendments, if we are going to do that, it's not just any election at all, but the the referendum must have a certain minimum turnout. That is 40%. 40% of persons entitled to vote. And who is entitled to vote? Persons who are eligible to vote and have registered. So if you look at the registered voters, if you are going to have a referendum, you must have 40% showing up at the election, and Out of this 40 percent, as we indicated, we have to get the about 70 percent who will say yes to the proposed amendment. Otherwise, it cannot proceed. So you need 75%. Of course, the fact that the Constitution itself has provided the Constitution review processes, and also we have had in the Constitutional Review Commission and now currently the Constitutional Review Committee is evidence of how dynamic the Constitution is, or how the Constitution is open to dynamism, being responsive to changing needs in society. So, for example, I'll give you a typical example. If you look at Article 17 of the Constitution, okay, the anti-discrimination clause, various criteria have been provided regarding the anti-discrimination clause. And so Article 17, Clause 2, among other things, we say that a person shall not be discriminated against on grounds of gender, race, color, ethnic origin, religion, creed, or socio-economic status, okay? So these are the criteria on basis of which a person should not be discriminated against. Now, if we take gender, we've known gender to be a man and a woman, right? It is binary. Either you are a man or you're a woman, you're a boy or you're a girl, as it were. And for that matter, we also knew that it was just a matter of heterosexual, orientation. But we live at the times when other ideas and other happenings have come up in some other jurisdictions, and our own people have also joined the debate. So you ask yourself, should we, for example, amend Article 17, Clause 2 and say that sexual orientation is also one of the criterion on basis of which a person cannot be discriminated against? Well, that cannot be done unless there's a referendum, as it were. I mean, I said that just as an example for you to see how having a certain aspect of the Constitution declared as entrenched and requiring a higher participation is important. Now, the weaknesses of the amendment procedure will have to be touched on as part of a good answer. Rigid threshold may block needed reforms. For example, you say that 40% of those registered to vote should take part in a referendum to amend entrenched provisions. And then when they are taking part, out of that, 75% of them should agree with the proposed amendment. You may get the 40%, yes, taking part, but you may not get, let's say, the 75% voting yes. If you get even 74%, you haven't succeeded. The referendum has failed. You see how difficult is it? If you get even 75.8 or 0.9, approximation does not work here in democratic election. We don't just approximate, because every vote is cast by one human being. So we cannot approximate to the nearest. So the referendum will not have been successful. So these are some of the downsides as far as the review or the amendment procedure of the Constitution is concerned. Of course, we also have a slow implementation of review recommendation, and that undermines evolution. If you take the 2010 Constitutional Review Commission, what the commission did, very good recommendations, but the states, delayed in actually implementing the recommendation. For that matter, some of the recommendations have become outdated or obsolete. They are no longer fit for purpose. They were useful at the time that they were made, and if they have been implemented, it will have brought certain desired changes in society, but that was not. And of course, there's a risk of also politicization or executive inaction. We can cite even the 2010. The 2010, the government did not do much to actually implement that. And significant time, energy, and resources were actually used in that Constitutional Review Commission. And I happen to have worked with the commission as one of the original researchers, so I know what I'm talking about. Okay, then, of course, a good answer must always provide a conclusion. So, having said all this, you come back to the original question and made the point that the 1990 Constitution has mechanism to adapt and evolve. However, for it to be truly a living document, legal procedure must be matched with political will and implementation. The Constitution evolved not just by design, but by use. And that is why there were some eminent persons, including, I think, Nana Dr. S.K.B. Asante, who was the chairman of the Committee of Experts, the Oman of Asokore Mampong. No, sorry, Asante Asokore, no Asokore Mampong. Asante Asokore, if that's it. Giving the caution that he is not for regular amendments, and you have to be very slow and allow the Constitution to actually evolve with use and practice than the judicial interpretation, as the case may be. Yeah, so that is what a good answer will be. So that is the guide and the sample answer, like all that we have said. Like look at the introduction, not much, very few lines. A statement that the Constitution was a living document capable of evolving into society that they govern. We try to explain it, encapsulate the idea that a Constitution must be adaptable to changing political, social, and economic context. A rigid Constitution may become outdated, unable to respond to new challenges, while a Constitution that allows for carefully considered change remains relevant and effective. The 1992 Constitution of Ghana seeks to strike a balance between stability and adaptability through its amendment and review procedures. So if you have this as introduction, when your examiner reads it, the examiner will be nodding his head that this candidate knows what he or she is going to do. So let us be mindful of it. And of course, the rest are developed. Yes. Just this is like a sample answer based upon what we have discussed. Okay, so the takeaway is that you must list 3 or 4 authorities minimum, which you use in answering like a particular question, isn't it? You have to manage, your time well, and if you know fewer number of cases very well, let's say that you know 3 cases very well, it's better to use them in your answer than to try and write, let's say, 7 or 10 wrong cases. And again, in terms of use of authority, you start from legislation first. But in our context, if there's a constitutional article, you use that first, followed by statutory provision before citing cases. When you are dealing with constitutional law, don't make a mistake of citing cases first. Okay, because we have a written constitution, and everything you're dealing with, there's a relevant provision in the constitution. So you must start from the relevant provision of the constitution before you talk about the relevant case law. So this is just an example of how we should structure our answer. We've discussed the IRAC and all that, so I'll not belabor the point. We will just move on to, we'll leave this session and move on to session 2. But before going to session 2, I will allow some 5 minutes of Q&A. Then I'll pause for 3 minutes and then we come back to have session 3. So if you want to make intervention, please put up your hand. Let me stop the recording.